So we have another new development in the Duncan versus Bonta California magazine ban case that is currently sitting in front of the Supreme Court. Just a few days ago, the plaintiffs here in this case filed a supplemental brief telling the Supreme Court that a brand new decision out of DC creates a direct split among the courts over magazine bans. But now the state of California has fired back. The state has now filed its own supplemental brief responding to those arguments, and they told the Supreme Court that the Benson ruling does not actually create a conflict that requires the court to now step in. So in this video, we're going to break down what the plaintiffs argued about the Benson ruling, how California responded to those arguments, and what this means for the chances that this case may be granted review by the Supreme Court. So let's talk about what is going on and what's developing in this critical magazine ban challenge. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. Also, you can click the like button that just tells the algorithm that you appreciate this content, and so it shares it to more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to give you as much as possible as a member. They're always expanding upon their benefits and trying to give you, as much as possible. Now, one of the cool things that's also relevant for what we're talking about here in this video about magazine bans is that AOR does not have a bunch of exclusions. So maybe if you're in a state where they have these magazine bans and maybe you act in self-defense, but you have one of these prohibited items, AOR will still cover you in that self-defense case. So that's just one of the benefits that they actually offer. They don't have these exclusions. They have a lot of other benefits that they're also adding in periodically. So if you're interested, if you want to check them out, you can use the links down below in the details section, also in the pinned comment. And if you sign up using my code ARMEDSCHOLAR, you can get $25 off of your sign-up fee. Now, as I mentioned in the intro, we need to talk about some new developments in the California magazine ban challenge, Duncan versus Bonta, that is seeking Supreme Court review. So first, we need to recap, what is going on with Duncan, where does it currently stand? Essentially, this case is a challenge to California's ban on magazines that hold more than 10 rounds. In this case, the Ninth Circuit sitting en banc ultimately upheld the California ban, and the plaintiffs then decided to file a petition for cert, asking for the Supreme Court to take the case and review the California magazine ban. And recently, the plaintiffs in this case filed a supplemental brief pointing to a new development that came out of Washington, D.C. Now, let's also talk quickly about what happened in Benson, which is so critical for what is now developing in the Duncan case in front of the Supreme Court. So the D.C. Court of Appeals ruled that the district's ban on magazines that hold more than 10 rounds does in fact violate the Second Amendment. Not only did the court strike down the magazine ban itself, but it also vacated several of Benson's related firearms convictions. Those included the possession of an unregistered firearm, the unlawful possession of ammunition, and carrying a pistol without a license in the district. So the court said that those convictions were infected by the unconstitutional magazine ban and therefore could not stand. So that was a sweeping ruling with potentially massive implications, and that is now being pushed in front of the Supreme Court as a reason for why the Supreme Court should grant review to Duncan. The plaintiffs here in Duncan told the Supreme Court that Benson creates a direct split between appellate courts and that the Supreme Court should now take Duncan to resolve this issue nationwide. But now California has responded to that supplemental filing, so they filed their own arguments to the Supreme Court. And in its new brief, the state argues that Benson does not actually create the kind of conflict that requires Supreme Court review just right here and now. And California makes several key arguments for why the Supreme Court should continue to wait on this issue and punt this case. The first argument California makes is procedural. According to the state of California, the Benson ruling is not yet final. DC has already filed a motion asking for the DC Court of Appeals to suspend that precedential status of the opinion while it seeks rehearing before the full court. That rehearing request is expected to be filed very soon, so it has not yet been filed or granted, and California argues that if the full court agrees to rehear the case, the panel likely, and their decision potentially could be, a vacation and reversal of that ruling that happened in the Benson case. So according to the state of California, the Supreme Court should not yet treat Benson and that ruling as a definitive conflict just right now. Instead, they should wait to see how this develops procedurally and if a rehearing en banc is granted by the court. California also argues that the alleged conflict between courts may disappear entirely, because if the DC Court of Appeals grants the rehearing en banc, the full court could overturn that panel ruling. They argue that if that happens, the claimed split between the Ninth Circuit and the DC court would no longer exist. So California tells the Supreme Court that it should wait to see what happens in the DC proceedings before they decide to step in. California also points to another unusual detail in the Benson case. So according to the filing, the United States government had already moved to vacate the defendant's conviction for possessing the magazine before the court actually issued its opinion. That means that the case potentially could have been resolved without reaching the constitutional question. California suggests that because the conviction was already set to be vacated, the court may not have needed to rule on the Second Amendment issue in question at all. And that is another reason that the state of California argues that the Supreme Court should not rely on Benson as the basis for granting review. So where does this leave us in the Duncan versus Bonta case that is seeking Supreme Court review? Well, right now the Supreme Court has the original cert petition, the plaintiff's supplemental brief citing Benson, and now California's response arguing that Benson does not change anything and should not be a reason for the Supreme Court granting review to Duncan. At this point, the justices will decide whether they think that the conflict among the courts is significant enough to actually take the Duncan case. And that decision could come up, maybe in a relist. So we're still waiting to see if Duncan gets relisted for a new conference. And we could also see potentially something in an order list. The bigger picture here is that the legal battle over magazine bans is now escalating. Courts across the country are now reaching very different conclusions about the exact same constitutional question about whether magazine bans are constitutional or not. Essentially, they're trying to see if magazines themselves that hold more than 10 rounds are protected arms under the Second Amendment, or can states just simply ban them like states like California, New Jersey, New York, and others do. The plaintiffs in Duncan argue that the courts here are now split on the issue of magazine bans, but California argues that this claimed conflict is premature and that the Supreme Court should simply stall this case, still wait, punt this issue, and not decide whether it's time to finally resolve this issue. They claim that the time is not yet here and that, again, this case should be punted. So that's the latest development in the Duncan versus Bonta case that's seeking Supreme Court review. The plaintiffs pointed to Benson and that ruling as evidence of a court split. California has now responded saying that that decision is not yet final and should not drive the Supreme Court to grant review to this case. Now the Supreme Court justices will decide whether to grant cert in this case, and we're also going to wait to see if they decide to relist Duncan. And if they do, Duncan could become one of the most important Second Amendment cases that we've seen in years. So as soon as we hear more about what the Supreme Court decides to do, as the arguments, escalate in the Duncan case based on what happened in Benson, and as Benson also develops procedurally, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.